We sometimes think that some things are too big to fail. They wanted to get the wind farm finished as quickly as possible because presumably they believe that once it's built, nobody's going to make us tear it down. And so they went ahead and finished the wind farm. They continued using illegally mined rock to finish the wind farm. So the federal government then sued NL. They sued on behalf of the Osage Nation. In December of 2023, a federal judge finally made a ruling, and here's the deal.
Welcome to the Land Department Podcast. The state of land and energy as we see it.
Brent, this is a really interesting topic, and it's going to be something that will be going far into the future and have big implications. How did you hear about Doug? How long have you known Doug?
Well, Dudley has known Doug for 30 years. Our company's worked with him on several different occasions over the years, and I haven't had the privilege to meet Doug in person, at least in quite a while. We've probably crossed paths in landman circles, but I saw some articles that Doug published about this topic, and I reached out to him kind of cold, and then we kind of reconnected, and we talked about all the old times and all the people at Dudley that he knows, and the work that we've done for him in the past. We've got a lot of shared friends and connections and history in this land business. So he was kind enough to join us and talk about Osage Wind today.
Yeah, welcome to the podcast, Doug. Thanks for joining us.
Thanks, man. It's a pleasure to be with you guys.
Yeah. What got you so fascinated into this? Like, you have written some lengthy articles. I read the one on Medium. How did you get into this topic?
Well, to be honest, you guys probably know Robert Bryce, Power Hungry podcast, and he's an author and movie maker, producer, and he's a friend of mine. And he did the original reporting on this story, and I was totally unaware of it, which is kind of strange because I am a lifelong landman. I went to University of Oklahoma, studied petroleum land management. First started working in oil and gas in Oklahoma and Kansas, so it's kind of weird that I didn't know about this story before Robert brought it to my attention, but I heard about it from him. And then with his blessing, I said, I want to do a deeper dive into this story. And so I started reaching out, interviewing people, doing research, went to Osage County about a month ago and met with some tribal members. And the story is just fascinating. As a landman, it's a fascinating story. It's fascinating because it's taking place in Oklahoma. I have a lot of interest in Native American issues, and so all of those things kind of converged to make me very interested in this story.
Yeah, and it kind of sunk home with us as landman because at Dudley, we're doing a bunch of renewables work, and we are really striving to educate our clientele on that side. And what we tend to find is you can give them technical expertise and advice, but if you give them a cautionary tale, like this is how bad it could go, it seems to sink in. And I think that's just human nature. And as I read through his articles and talked to Doug about it, I was like, man, this is a perfect example to tell a story and really just provide a tale. These are things you have to take seriously. You can't blow these things off. You have to kind of check your boxes and do what's right. And so I thought this would be a great topic. So again, thanks for joining us, Doug.
Sure. And as professional landman in the oil and gas business, of course, my degree was petroleum land management. Now, excuse me, there are no schools that teach petroleum land management anymore. They teach energy commerce or energy management or whatever, because the same principles that apply to petroleum land management apply to renewable land management or, wind land management. But for historically, the oil and gas industry has done a really good job of understanding the importance of land work, the importance of understanding land ownership, the difference between surface ownership, mineral ownership, all the types of ownership issues that go into developing an oil and gas property. You can't develop oil and gas without owning the land, owning the mineral rights, owning the surface rights, all of that stuff. We know that. And I've gathered from my friends that work in the renewable industry that a lot of the renewable industry, not Dudley, of course, but the companies, especially the foreign companies, do not really have a good grasp and understanding of the importance of how the land professionals can make their project successful. Because if you build a wind farm or a solar farm and you don't have the correct rights, then it can explode the whole project. And so that's kind of what this is a story about.
You're very much exposed, and it's not necessarily their fault. You have a lot of people coming in the space, a lot of people from overseas. The whole concept of fee ownership and individual ownership of mineral rights is foreign. So
Absolutely.
we get that, and even more so on the domestic groups that we work with. They're engineers, they're maybe real estate professionals. They just don't understand it. So the industry is coming around to recognizing the value of a land professional, a landman, and we're on tours across the country at different conferences talking about the importance of managing and mitigating your mineral rights and the working interest rights for leasehold and all those things that kind of show themselves in this story. I guess with that, Doug, let's kind of dive into it. We thought maybe we could just kind of lay the groundwork about where this happened, maybe a brief overview of what happened, and we can dive into the story.
Yeah, let's talk a little bit about the Osage tribe because it really starts with them, and they're a very interesting uh, Native American tribe. Of course, like all the tribes, they emerged over time and they moved and they had different home areas. And I think that the Osage tribe, as we sort of know it today, is probably could be recognizable back for the last 1,000 years or so. And they are descended from the Sioux tribe. So sometimes I've heard them referred to as the Southern Sioux, which I had never heard before. But their homeland, let's say, for the last 1,000 years or 800 years, has been mostly centered around Missouri, Ohio River basins. And it stretched a long area because they would hunt over a large area going up north into Iowa, as far east as Kentucky and south in Kentucky, and as far west I've heard even into Colorado at some points. But Arkansas, Missouri, Oklahoma is kind of their homeland. And as was the case with most native tribes, they kept being encroached on by European settlers, and they were pushed out of their traditional homeland, being kind of the Missouri area. They kept getting pushed further and further west, and eventually they were put on a reservation in southeastern Kansas, and where they were there during the middle part of the 19th century. And then again, the encroachment from Europeans kept pushing them further and further. And the federal government eventually purchased the land, their reservation in southeastern Kansas, I believe it was around 1870, 1872, and said, we need this land for white settlers. And of course, that's a whole nother subject. That's a whole nother issue
Yeah.
that we don't have time for today. But the interesting part is they were paid for their reservation in southeastern Kansas, and the tribe took that money and they purchased their own reservation in Oklahoma, which is very interesting because, Oklahoma was the Indian Territory. They had pushed the five so-called civilized tribes, Cherokee, Choctaw, Chickasaw, Creek, and Seminole tribes from southeastern United States. They had moved them across the Trail of Tears to Oklahoma. You had a lot of other tribes that were consolidated into western Oklahoma. So that was called Indian Territory. And in most of those cases, those tribes were allotted or given um, reservations and incentivized to move to Oklahoma. The Osage had their own money and they bought their own reservation, which put them in a little bit different situation than the other tribes. And they actually bought Osage, what is now current day Osage County. They purchased that from the Cherokee Nation, who had a big
Okay.
reservation, and they sold part of it to the Osage. And they created their own reservation with their own money. And it's also interesting because the Osage have always had a history of being educated. They saw the value of education. They saw what was happening to the other Indian tribes as a result of the white colonization. And so they put a high value on education. And in the 1800s, they had actually asked the U.S. government to see about locating religious groups on their reservation that would help teach them the way, educate them, and eventually teach them the ways of the white man, which would position them better to negotiate better deals with the white man.
Yeah.
So we were a step ahead. And when I went to school at University of Oklahoma, we had to study Indian law, and there was basically considered three types of Indian law in Oklahoma. There was the law of the civilized tribes. Now, these are not my terms; these are legal words of art, so don't blame me for calling it. But they basically called the 5 civilized tribes from the southeastern United States civilized tribes because they had been around the white man long enough to have learned enough that they considered them civilized enough to deal, at least at some level, with their own real property. So the rules applying to them were different than with the wild tribes. The wild tribes were, again, another word of art, not my word, that I'm just quoting it. Wild tribes were Apache, Comanche, Kiowa, Arapaho, other tribes who had not been exposed to white people as much and were generally considered to be not educated enough to deal with their own real property. So there's a different set of rules for the wild tribes, and it was basically an effort by the federal government to protect them from being taken advantage of by white people. And then the third type of Indian law is the Osage. The Osage are kind of unique, and that's because they bought their own reservation. They were very smart. And when they negotiated with the federal government, they negotiated a better deal for themselves than some of the other tribes. And one of the things that they negotiated was, so let's go back. Basically, the U.S. government wanted to incorporate all the Indians into the U.S. and make them U.S. citizens. And the way they would do that, they wanted to do that so that they could eliminate tribal rule and get them sort of indoctrinated into the white way of civilization. And so they would allot the lands to the individual tribal members. In return, they would get U.S. citizenship. So when it came to the Osage,
Okay.
they allotted all the land in the county. All of Osage County was divided up among the members of the tribe in I think it was 1906. Whoever was a member of the tribe in 1906 got a certain percentage of the land in Osage County. But uniquely, the tribe kept all the minerals for itself. So over time, I don't know what the percentage is, but I'm guessing probably 90% of Osage County now, the surface is owned by non-tribal members. The tribe, they got married, they sold it, they lost it, whatever. But most of the surface of Osage County, a large percentage of it is owned by white people or non-Osage. But all the minerals are still owned by Osage County. So that's kind of the historical background of how we got here. And of course, you know about the story of the it was recently made into a movie about the taking advantage of the Osage during the oil development in the 1920s and 1930s. A tragic story. Great movie.
Great
Killers of the
movie.
Flower Moon.
Tragic story. But so that's kind of what got us to today as far as, different surface ownership from the minerals, but also lays the groundwork for a very sophisticated tribe when it comes to managing their business. And that has a long history recognized from their early times when they got to Osage County.
Exactly.
So flash forward to,
2009.
someone shows up.
Yeah, I think 2009, 2010, a lot of wind development is going on in the U.S. and a lot's going on in Oklahoma. I think Oklahoma built their first wind farm about 2001. By 2009, we've got wind farms popping up all over the place. And so according to the tribal members that I've talked to, they started first hearing whispers about wind energy coming to Osage County in 2009. And let's be honest, the tribe never wanted wind development in Osage County. They valued their landscapes. They valued their vistas. They have, one of the largest the largest remaining tallgrass sanctuary in the U.S. is still in Osage County in southern Kansas. So I think it's fair to say most of the tribal members were not enthused about having wind come to their community. And in fact, I think that, and of course, the bald eagle is sacred to them, and they knew that was going to be the bald eagle would be impacted by wind turbines. So early on, the tribe went to court and asked the court to stop the development of the wind farm up there, basically because of their traditional values, even though they owned, didn't own all the surface. They just said, this is still our reservation and we still would like to stop it. And the federal court says, you really don't have a basis for stopping this. If there's private surface owners who want to develop their surface and they want to sell the rights to develop a wind farm, we don't have a basis to stop it. So the wind farm proceeded. And as you know, generally when you buy a wind lease, because you guys do this type of work, when you buy you're buying a lease from the surface owner to put a wind farm. You don't need mineral rights to build a wind farm. It's like in the oil and gas business, you have to have a surface right so you can locate your drilling rig, but you also and your facilities. But you also have to have the mineral rights. But on a wind farm or a solar farm, you don't need the mineral rights to develop a wind farm or a solar farm. And so the company that eventually became NL did not do the original development, but they did eventually buy into the project. Bought into the project. NL, which is a European, Italian-based energy company, a big renewable developer in the U.S. and around the world. They came in and they had these surface leases, and they were completely within their rights to build this wind farm. And as you guys know, when you own a surface ownership, you also have the right to use a reasonable amount of the subsurface for the enjoyment of the surface. So, for instance, if I wanted to if I bought a little tract of land in Osage County and I wanted to build a house, I could build a foundation for the house. I could build a swimming pool. I could build a basement. I could go into the subsurface because the surface owner is afforded a reasonable use of the subsurface. I'm not allowed to mine the minerals underneath that but I am allowed to go into the subsurface for the reasonable enjoyment of the surface. So had NL just done that, they would have been fine. So they dig down these massive, and they are massive foundations for these wind, because you've got wind turbines that are standing 400 feet tall, and you got huge pressures against them. So you're digging down a foundation, you're pouring steel and concrete into the ground to hold this massive wind turbine. And they did dig these holes, and they had every right to dig these holes. And then they put these foundations in. But what they didn't have the right to do is to take the material that was dug out of the holes and to make commercial use of it. And they had taken the rock that came out of the ground, and they had taken it to a rock processing plant, and they had crushed it, and they had refined it, and they had sorted it and made it into commercial grade materials, which they then used illegally. So when
what was their use of it, Doug? So
I think they used it for the concrete. They used it to mix in to make the concrete for the foundations. And I've been told, now I don't know if this has been documented, but I've been told that they also used it for the roads and the pad sites and stuff. So they used it for the construction of the site.
And in your research with the Osage and this whole story, was the rock that was extracted within the pads, or did they reach outside of those pads? Did they have a broader mining effort?
They did both. They took the rock from the excavated holes, but they also, because they didn't have enough rock from those holes, they actually open pit quarries adjacent to these and mined additional rock. And we have pictures of this. I think there's a picture in the article showing the wind turbine and adjacent to it, like a 50 or 60 foot wide pit that's 30 feet deep, where they were excavating an additional rock besides what was just taken out. So and had they wanted to use that material, they should have had a mining permit from the mineral owner. Now, in some cases, the surface owner and the mineral owner are the same. So if you go buy a wind lease from somebody and they own the surface and the minerals, you could lease the surface. Or if you think the rock underneath the property is valuable and useful, you can incorporate that into your wind turbine lease.
Yeah.
That's your agreement, whatever agreement. But NL did not have a mining lease because the mining lease had to come from the tribe. So after they excavated the first hole, the tribe very astutely notified NL that they didn't have the right to use that rock. They said, look, you have the right to build the wind farm. We don't like it, but you have the right to do that. You do not have the right to take our rock. And they thought that, if NL had been smart, they would have just basically stopped using the rock. They should have just piled it up in a pile next to the thing and not used it. They could have brought in concrete from Tulsa or Sand Springs or wherever. They could have bought material outside. They could have, but they didn't. So they continued mining the rock illegally. Again, not just excavating it, but crushing it, refining it, sorting it into commercial materials. So now the Indian tribe, the Osage tribe, then goes to the Bureau of Indian Affairs in Washington, D.C., and says, this is what's happening to us. We need your help. The Bureau of Indian Affairs researched the matter, and they came to the same conclusion that they were illegally mining this rock. So the Bureau of Indian Affairs then sent a cease and desist letter to NL at their home office in Rome and said, if you want to keep building the wind farm, fine, but if you're going to use the rock, you need to stop until you get a permit. NL basically was rude. They did not respect the sovereignty of the nation. They didn't respect the Bureau of Indian Affairs, believe it or not, and they kept mining the rock. It's almost unconscionable.
Yeah.
And I think, we sometimes think that some things are too big to fail. And I've had several of the tribal members say, as soon as that letter went to NL, the NL, instead of just constructing during the day, they accelerated their construction and started doing 24-hour operations. Now, I mean, I don't have my own, that's just what I'm told by tribal members.
Mm-hmm.
But the idea is that presumably they recognized they had a problem. They wanted to get the wind farm finished as quickly as possible because once it was built, presumably they believed that once it's built, nobody's going to make us tear it down.
Yeah.
I mean, get
It's
it built.
too big. Yeah. It's unfathomable.
Too big to fail. Yeah.
Yeah.
And so they went ahead and finished the wind farm. They continued using illegally mined rock to finish the wind farm. They put it on production, I believe, in 2015. And since 2015, they've been making lots of money off of federal subsidies, and they've been making lots of money selling electricity. Well, not only was everyone was appalled at their audacity for continuing to do this blatantly after being warned not to. So the federal government then sued NL for trespass and for illegally mining without a permit.
So the federal government stepped in at that point.
Yeah. United States of America versus NL. And they sued on behalf of the Osage Nation. And this has wound its way through federal court for 10 years. And then in December, it took from 2014 till 2023. In December of 2023, a federal judge finally made a ruling. And here's the deal. First of all, they found that the NL had illegally trespassed, had illegally mined the rock. I believe, and this is just an opinion, that had they stopped doing what they were doing, the illegal mining, they could have finished the wind farm without the illegal use of the rock.
Yeah.
And I believe that they probably would have been slapped on the wrist, given a fine.
Yeah.
You probably would have had to pay for the rock and maybe some sort of a fine for whatever they did. That probably would have been the consequence had they just heeded the Bureau of Indian Affairs' original admonishment. But instead, they doubled down, kept mining. And I think the court was so appalled by their audacity that instead of just giving them a slap on the wrist and just giving them a fine, the court has now ruled that they must take down all 84 wind turbines and restore the surface back to its original condition, just like an oil company would have to do. And I've seen cost estimates ranging from $250 to $300 million to do the reclamation work. And of course, they're not going to be able to continue operating the wind farm.
So, wow, so many questions.
Yeah.
So, okay, 2023, they're ordered to dismantle and restore the surface. Was there additional penalties, damages awarded to the Osage tribe?
So that was the first punitive thing, take down the wind farm. And of course, NL has not learned their lesson because they were told to stop operating the wind farm and start dismantling it. Not only have they not started to dismantle it, I was out there 4 weeks ago, and those wind turbines are still operating. They have refused to stop operating. So they're making they're making the court madder by the minute because they have not heeded any of the court order. Then the tribe has asked for punitive damages. And actually, this week, there is a hearing in Tulsa going on right now where the tribe is setting forth their claim for punitive damages. Of course, there's the value of the rock, but there's also, they're saying, you've diminished the value of our land. You've prohibited some oil and gas development because we couldn't lease this land because there were
Subject
wind
to
farms on it. We couldn't use
litigation and wind
sites.
farms. Yeah.
Yeah. So the tribe right now, at this very moment as we're speaking, the tribe is setting forth their case for additional damages. And then NL is, of course, given the opportunity to refute that. And I read an article in the Tulsa World last week that said they were hoping to have a decision this week. Now, this week is today, so it's Friday. I don't know if we will hear, but in the next week or so, we should hear the amount of additional damages, if any, that are going to be assessed against NL. But I have also heard from some member of the tribe that the amount of money that they're asking for is in the amount of dollars that starts with a B, presumably billions. So, I mean, I can't say that's true, and I am not attending the hearing, but they're asking for a lot of money.
Yeah. So they were ordered to dismantle and cease operations on their entire project. Correct?
Exactly.
Right. So it wasn't just isolated to the portion that the Osage tribe had minerals on, or I guess the whole farm was on the mineral estate of the Osage tribe, right?
Yeah, they're going to take down all 84. They got to remove the foundations. They got to remove the roads. They got to remove the power line infrastructure, the substations. They got to remove it all and restore it back to the original.
Wow. So
And
does NL own other and operate other wind farms in the United States, or is this?
absolutely, yeah, they do.
Yeah.
I think they own other ones in Oklahoma and Kansas, and I think their subsidiary that owns this is actually NL Kansas LLC or something like that. So,
Okay.
yeah,
Okay.
they're a big operator.
Goodness. So I wonder for the surface owners, right, that were receiving revenue from these operations. I mean, I guess they're affected in some way because it impedes their revenue stream.
Yeah,
Is there
yeah. Of course,
any
they're not happy
considerations
about
for
it.
that? Yeah, they're not
Yeah,
happy.
they intervened, and I believe, now I don't want to say absolutely, but I'm pretty sure that one of the owners of one of the tracts that was leased to NL is the Chief Justice of the Oklahoma Supreme Court.
Oh,
And so, but I think he's remained out of this. I understand
probably
that he's a very
understands.
honorable person.
Yeah.
He's not involved himself at all, not putting any pressure on it. But of course, all the surface owners stand to lose a lot of money. The county stands to lose a lot of money. The Shattuck School District stands to lose a lot of money because there was a lot of the revenue that was going to be going to the school district there. So yeah, there's a lot of losers in this as well.
Yeah. It's just an unfortunate situation. What is NL's, have they given an official response? What's their statements?
Of course they're continuing to fight this all the way, and I don't know whether they're getting bad legal counsel or whether they're getting counsel and they're just stubborn. But they push back, and I think their initial reaction after the December hearing was, we're appealing this. We think this is a bad decision. It's going to hurt the school district. It's going to hurt everybody. We don't think we should have to do this. I don't think it's going anywhere. The original decision has been appealed and has already been appealed and has been rejected for a review by the Supreme Court. So I don't think they're gonna. I don't think they're gonna win.
It's gonna end there.
There's
So
one
they've had
other.
been a 10-year battle, right?
It's been a 10-year battle, and I mean, this isn't going to probably be completely resolved here for another few years. But I think the Indians are probably going to prevail.
So many. It's a twisted web of a story. It really is.
Yeah, one other
Um,
thing that I uncovered while researching this was I there's some NEPA considerations here, which National Environmental Policy Act aspects, which I have not seen reported anywhere else by any of the other people who are covering this story. But as you guys know, if you're working on federal property or any kind of property that has a federal nexus, then you have to comply with the National Environmental Protection Act. And I have confirmed with the Bureau of Indian Affairs in Oklahoma that in order to do a mining project in Osage County, you have to do a NEPA review. You have to do an archaeological review. You have to do all an environmental assessment like we do with oil and gas to see if there's Indian artifacts, if there's burial sites, if there's cultural sites, all those sorts of things that we deal with in the oil and gas business. The wind industry, I mean, would have to do that if they were operating on federal property. They also have to do it if they're mining
they're going
rock,
to mine. Yeah.
if they're going
So
to mine.
by
And
virtue of that defined mining operation, they back
exactly.
into requirements there that they've also violated.
Yep. So the Bureau of Indian Affairs has confirmed that they should have done a NEPA review. Now, not doing a NEPA review or not doing an environmental assessment on a federal tract is a serious issue. And I think NL's position is, well, we didn't think that we were mining because they've always taken the position they weren't mining. They were just digging up rock and using it to build the wind farm. And they said that's not mining. But the courts have now determined it is mining. And so if it's mining, then they needed a NEPA review and an environmental assessment, and that hasn't happened. So I think they could be under some pretty serious trouble with the federal government for failure to comply with NEPA.
Is that a
Yeah.
common practice for other wind developers to mine rock now that we know that it's mining and use that for their projects? And what does that do to other wind farms that are out there?
I have talked to a number of people about this, and I think this is the answer I've gotten is that sometimes you do use the rock that you've dug up, but you always have an agreement with whoever the owner of the minerals is. So if the surface and the mineral owner are the same, you're just dealing with the same person when you buy the surface lease. And then there are other cases, like in this case, if the rock is not suitable for the need for, it's not the right type of rock that you need, then you bring in material from an outside source and you bring in
Purchase it
concrete.
from wherever.
Yeah. But you guys do a lot of renewable work. So what's been your experience?
Well, it typically it's handled as a part of, you have waiver and joinder by the mineral estate in your efforts as a part of your insurability for the project. And, it's back in the mid 2000s that we were doing a lot of this wind work, and it still goes. It's not as prevalent today as it was back then. But yes, I mean, common practice, you secure rights from the mineral estate if you're going to mine or do anything to that effect. I think it's not something we dealt with commonly, right? It tends to work itself out by purchasing material and all the things that you need to do for construction. It's my question is, in the court proceedings and in the rulings and whatnot, did the court specifically kind of opine as to if they would have taken the rock that was used in the construction of their pad, just that rock, the 60-foot circle or whatever it may be, and use that material in any way, would that have been in violation? Or was it strictly because they went outside of that construction site, open pit mined an area, is that what triggered it?
I think it's a little complicated. Clearly, if they went outside the foundation and opened a rock quarry there, that's
Yeah,
clearly
it's pretty
an
black and
circumstance.
white there.
I think if they had taken the rock out of the hole, piled it on the side, put in the concrete foundation, and then filled in the hole with rock, and just took the old rock and filled it in, that would have been fine. You took the rock out and you put it back in. What constituted the mining was the fact that they did not want to use the rock in its current condition. They wanted to load it on a truck, take it to a refining company, crush it, refine it, sort it into commercial materials that, would be typically what you do if you're mining rock. You take the raw rock and you make it into commercial grade material through all this processing. So the fact that they processed it before they used it is what caused it. So even if they had not opened pit quarries outside of the foundation, they
still made commercial use of it.
They still made commercial use of it. Yeah.
Okay.
And I do remember the other thing I was going to tell you a second ago. I was interested in this story because of being an Okie and because of being a landman, but I was also interested because I do listen to podcasts about all sorts of energy every week just to keep myself abreast of what's going on in renewables and solar and wind. And I was hearing on a wind podcast, some podcasters were really unfairly characterizing this story and saying the Osage were unreasonable, they were greedy, they shouldn't have waited till the end to notify NL about this. And of course, the records now indicate that they notified them immediately, early on, before they even finished their first wind turbine. So I felt like the coverage from the wind industry was unfair. Now, I don't know that they were overtly going out of their way to make it look like the Osage were bad. I think they were just uninformed. They didn't know what the real cases were. And so they were extrapolating, this is disaster for the wind industry because this is going to shut down all wind production across the country.
Anybody can come back now and, claim X, Y, and Z.
And I kind of felt motivated to dive in and figure out the facts and research the facts. And it's not my job to come defend the Osage tribe, but I felt like, in fairness to them, their story needed to be told honestly and fairly. And so that was the other reason why I jumped on this story, because I felt like they were being mischaracterized and demonized a little bit by the wind industry. And I didn't think that was fair to the tribe. So.
No, I think it's a good point. They need a voice as well. And the fact, to your point, they did everything right. In this case, everything was done right.
Yeah.
I wonder what it would be like if, say, for instance, now that this precedent is set, and Enel obviously followed this business practice, did they do that elsewhere on their other projects? And what is the fallout that's going to come from that potentially?
Yeah.
Yeah. Now,
and we'll look at it the same way. If those owners show up now, 10, 15, 20 years later and claim this, do they have such a heavy hand?
Yeah. I think it's a more difficult fight if you didn't raise your hand at the time that it was happening, probably.
Yeah.
I mean, I'm not saying it couldn't be. So you're right. It's possible this could affect other wind farms if you could prove that other companies and other places had illegally mined rock. But in this particular case, they knew up front, they were told, they were warned, and they continued to defy the court and the Bureau of Indian Affairs and the tribe. And so I guess my point is I don't think this is going to have far-reaching effects on existing wind farms. I don't think this is setting a precedent where, oh my gosh, now we can't build wind farms in the U.S. You just got to build them right. You just have to do it right in the law. So that was one of the things that the wind farm podcast said was, oh, well, this just changes everything. This is setting a precedent where we're no longer going to build wind farms in the U.S. And I'm like, that's not really what this is about.
It's not what it's about. Well, there's a certain level of ignorance, as we said, right? It's so surface oriented. So many real estate backed people or oriented people put these projects together, and they're very good at doing those things. But again, awareness. That's really why I wanted to have you on. Obviously, it's an interesting story. We're active in Oklahoma. We've been there for 44 years. I'm super interested in that part of Oklahoma. I love that country. And we're involved in all these sectors and work with mineral owners and surface owners and wind development companies. And really it's, tell the tale, tell what could happen, heed the warnings. If you get a notice for something, take it seriously. It can affect your project, down the line. And, unfortunately, we're seeing a scenario where there was a lot of money at stake. And obviously, Enel said, well, we'll just take the risk and fight this forever, and we'll make money for the next 10, 15, 20 years. Obviously is the mentality they took. It's unfortunate. And I hope that the federal government sticks to it and really, really makes them, heed their judgment and get the hell out of Osage County.
Yeah.
Well, the cautionary tale too is that you need professional landmen to help with these
Absolutely.
projects because
Absolutely.
let's be honest, land rights are different in every state. In some
Every
cases,
state.
even in within counties within the state, it's not always the same in each county, especially from a regulatory standpoint. And so,
Exactly.
people who work overseas, if you work in Italy, where NL's from, well, your ownership rights, your regulatory rights are going to be the same anywhere you operate. But
Yeah.
if you operate in Oklahoma, it's different than Texas. Surface rights in Colorado are different than surface rights in Texas, are different than surface rights in West Virginia. And the regulatory environment can vary by county, much less by state. And so it's important to have a knowledge of the land, legal, and regulatory environment where you're building these projects. And who better to do that than your trusty,
Your friendly neighborhood landman.
your trusty neighborhood Dudley Land Service. Honestly, that's the lesson here is that
Yeah.
these, especially these foreign companies, got to understand that the U.S. is a completely different animal from a land rights, a surface rights, a mineral rights, and regulatory standpoint than what they're used
It
to.
is. It is. And what we see is these companies, a lot of new companies starting, a lot of companies forming and chasing a lot of different things. And maybe they cut their teeth and kind of learn what's important to focus on in certain part of the country, a certain state. And then another market opens up, new incentives, new takeaway capacity within the grid opens up, and all of a sudden they're in Texas or they're in some other state. And they try to take that just general land knowledge and understanding, from Missouri and apply it to Texas or apply it to Arkansas or Mississippi or whatever it might be. And that's a mistake. So we really try to caution and urge them, if using whatever land service group you're using, make sure they have some knowledge and experience in that area because it's invaluable. If anything, contacts. At least a good landman isn't expected to know everything in every state, but they're expected to know when to throw up a red flag and when to, direct to legal counsel and direct to someone who's knowledgeable in that area. And we do a ton of that. You don't claim as a landman to know everything everywhere, but you know what you need to be looking for and what you need to take seriously and where it varies. There's some great resources that the AAPL puts out. The oil and gas law by state publication they put out is just invaluable for land professionals to use, especially folks work in the renewable space. We'll work with clients. They'll take us, take a landman that they've worked with successfully in one state and want to go to the next state and use that person because they built a rapport, working relationship, communication back and forth. We've copy and paste a snippet of that book every time we send someone to a new state. It lays the groundwork. It's a good resource. So we urge all field landmen and in-house landmen and folks working at renewables companies that are land professionals, have that resource, know where you can go to find the information to get the baseline answers you need that apply to that state, and just do good land work.
Yeah. And I know a lot of people in our industry, in the oil and gas industry, are now working in renewables. Some are working in both. They go back and forth depending on what their needs are. But I'm hearing some horror stories from people who have spent most of their life in petroleum land management and seeing how little attention the renewable companies, not everybody, I don't want to paint with too large a broad a brush,
Certainly.
but a lot of these renewable companies are not taking the title issue seriously. And the landmen who have spent their careers in oil and gas, they know before you go buy a lease, you go find out who owns the land so you know who to buy the lease from.
Yeah.
And maybe you spend some amount of money to do a cursory amount of title to buy a lease. Then before you go drill a well, you do a whole nother
You
level.
do even more.
You do more. I mean, you instead of doing the landman doing the title, now you go to an attorney and say, now I want an attorney to do a full-fledged title opinion to tell me before I spend $10 million on a well, I want to know that I own both the surface and the minerals. And I hear these guys that are former petroleum landmen working in renewables saying these renewable companies have no concept how important it is to do a proper title search. I mean, they're going out to the farm and saying to the guy,
What's your name?
What's your name? And
Yeah.
would you like $20,000 a year for us to put a wind turbine here?
Yeah.
And the problem is they're making a deal with the guy in his ranch. And if we did that in the oil business, we would be fired because we know just because the guy lives there doesn't mean he owns it. That doesn't mean it's
Yeah.
his real name. It doesn't mean that he doesn't have brothers and sisters who also own part of it. It doesn't mean that,
Yeah.
he properly inherit. I mean, all those things. So the title issues are not being taken seriously by
Yeah.
some of the renewable companies.
Especially early on. I think it's to a certain extent, you don't want to say it's understandable, but it's a maturing space, right? Oil
Yep.
and gas business has been around for hundreds, a long time. We've learned a lot of lessons along the way. Who's to say that the same thing didn't happen, in the Spindletop days and in the early days of the
That's
oil and
true.
gas
That's true.
development? So you try to equate it to that. The difference is there's information out there now, and we're starting to see that. You're starting to hear these tales. We do due diligence on these renewables transactions all the time, and we're costing people money because we're busting them on due diligence because they don't have their agreements drafted properly, or they haven't secured waivers of the mineral estate on their solar development that they're trying to sell. So people get enough licks and it costs them money and it delays their projects. They start to learn. And unfortunately, again, I kind of led this discussion with, we try to advise these things, but until you tell them a horror story, sometimes it doesn't sink in.
This may
And
be the
so
horror story that really
of
changes
all,
things because, in the oil and gas business, we all know people who have drilled a well on a property that
yeah,
turns out they didn't own. They
yeah,
drill a well and find out that actually Enron or EOG owned the lease. They had
yeah,
bought the lease before, or they bought it from the correct person. You bought the lease from the wrong person. And all of a sudden that well that you drilled a free well for somebody else.
I know.
This is that wake up moment for the renewables because if they're going to have to spend $300 million to tear down a perfectly good functioning wind farm, that is going to hurt
Yeah,
bad,
it
and it
will.
should be a wake up call. And I hear from my friends in the renewables that they don't do the same types of really detailed land work. For instance, how many times has a renewable company asked you to do a affidavit of possession?
Oh yeah, it's never. It's really their understanding of what's required in title solely revolves around title insurance and underwriting, right? And unfortunately, what we've discovered and experienced is that commercial underwriters in the title insurance space deal with surface properties. They're dealing with subdivisions. They're dealing with whatever you name it, right? Any kind of commercial development. Um, they're not dealing with commercial development that covers 1,000 acres, like a solar farm would.
Mm.
So their whole, hundreds of years of, title insurance identity is oriented to that. Well, you throw in these big energy projects and they're trying to take the behaviors and the process and the understanding of what's required and what's not from 200 years of just pure surface development and plugging it into these energy projects. And they're giving some bad guidance, or they're putting requirements in there. Just basically, they give a broad exception to the mineral estate, but they don't tell you what you need to do. Go get this, go get a waiver, go do whatever. But there's a lot of nuance to it. It's what led us into the title insurance game with in Texas with our insurance group,
Mhm.
so that we can really help navigate that and really resolve those things to be able to insure. And a lot of the work is working with the underwriters, explaining situations, explaining this, that, and the other, and why. I think about that wind project. Yeah, they may have gotten a title policy, but it's probably on the parcel that they constructed on. The title insurance company had no idea that they were strip mining, off site or off track.
Yep.
And so it's the blend of, what is the insurance company going to require me to do to insure my project? And what is my land department advising me as a good business practice? And are they watching my back? Are they taking care of me as a company on securing the proper rights and being able to operate in a prudent manner? And ultimately, that's what we want. It's an educational thing. This is a maturing industry. They're going to get better. We're seeing more and more land professionals, to your point, working in the space because those skills are very much transferable. It's great. I'm by no means an anti-renewables. I'm all of the above. Landmen do land work, whether it's in oil and gas or renewables, you name it. And they're finding a place there. And I hope that, when we look at the space over the next 5 to 10 years, it's going to get much better. They're going to be more prudent about their efforts, and, hopefully not have to tear your farm down, your wind project down
Yeah.
20 years from now because they neglected the advice of a good land professional.
Yeah, and I'm not celebrating this because I'm anti-renewable or anti-wind or
Oh,
anything like this.
absolutely.
I mean, let's be honest, we're going to need all the energy we can get. There's an appropriate place for all these types of energy. Wind's not going to work everywhere. Solar's not going to work everywhere. We don't want oil and gas everywhere. So maybe we're going to need some nuclear too. I
Yeah.
talked about
I'd
nuclear.
love to. That's a whole nother conversation. We'll
That's
have you
all.
on the podcast for that. Really interested in your work there.
But I do feel like the tribe has been vindicated, and in fairness to the tribe, they haven't been able to really defend themselves very much. They've got a complete gag order. Anybody in the tribe, I mean, I can find some individual members of the tribe who are willing to talk, but as a whole, they've been under a gag order
Really?
for the last 10 years. No, not from the court, but from their own tribe. They're like, we don't want to go out there and have people talking about this and say something that's going to, adversely affect us. So they've been very reticent to defend themselves. And that's another reason why I feel so good about being able to take this story out and tell it, because the tribe is just been very tight-lipped. They've just been very mum. They're going to let the court system handle this. But in reality, I think they've been treated somewhat unfairly in the news and in the press. And I'm just happy to be able to, go tell their story a little bit in a way that paints them in the fair picture that they should be painted. And in fairness to that podcast that had, I feel like, had unfairly characterized the tribe, after they read my article, they immediately called me back and said, "Hey, we want to get you back on
Well,
to
good.
set the record straight." So they're doing the right thing too. I mean, I never thought they were intentionally going out. I think they just made some assumptions based on lack of knowledge.
Yeah. I mean, we all, in today's world, we all tend to pop off and run our mouth a little sooner than we probably should. And unfortunately, our mistakes go out to the world if you're on the podcast scene. So,
as they
I'm
say,
sure.
words are fleeting. Once they're out, they cannot be recovered.
I tell my kids that all the time.
Yep.
That's great. Well, you've done a great job of telling their story and really educating everyone. Thank you so much for being on. We have your Substack article that is a great read, like really put a lot into that, obviously, 20-minute read probably, that we'll link in the show notes. How can listeners get in touch with you to learn more about what you do, but also about this story?
I think probably the best way, besides going to my Substack and subscribing to my Substack,
Yes, subscribe.
probably the best thing to do is reach out to me on LinkedIn. I'm most active on LinkedIn. I'm on Twitter, X, a little bit, but mostly I work on LinkedIn, and so that's how I'd recommend people reach out to me if they want to get a hold of me.
Great. We will
Awesome.
put that in the show notes for everybody, and so many great lessons to take away from this. I think probably the biggest one is no one's too big to fail, and shortcuts lead to dead ends. So thanks for sharing everything. Right. And we appreciate having you on.
Yeah.
Thanks, guys. Hope to meet you guys in person, and hope this is just the first of a long relationship. So let's do it again sometime.
You bet. Thanks so much, Doug.
Thank you, guys.
Thanks for listening to The Land Department. Check out our website in the show notes or visit dudley-land.com to learn more about us.